Good afternoon, everyone, and thank you for joining us today. I would like to welcome you to today's webinar entitled Higher Education Post-COVID-19, Legal and Compliance Concerns. This briefing will be recorded. Everyone who registered today will be registered for all future higher education-focused briefings. I want to address some preliminary items before we start today's briefing. Currently, all listeners' phones are muted. At any point in time during the presentation, please feel free to submit a question in the GoToWebinar question box. We will try to answer all questions. Today's webinar addresses the legal challenges higher education institutions are facing. The presenters include attorneys Natasha Baker from the Novus law firm and from FortneyScott, Elizabeth Bradley and David Fortney. I will now turn the program over to David Fortney to start our webinar.
Great. Thank you very much, and welcome everyone. We're really glad to have you. Particularly special welcome to Natasha Baker from the Novus law firm and to Liz Bradley. They are our subject matter experts, and they will be doing the heavy lifting today. Let me just ask briefly, Natasha, would you please introduce yourself briefly for the audience?
Sure. Hi, everyone. FortneyScott, thanks for hosting this. This is wonderful. Great to see everyone in the attendees. So my name's Natasha Baker. I'm the managing attorney of the Novus law firm in Northern California. It's a law firm focused on higher education, labor, and employment law. Thanks for having me.
Terrific. We're glad to have you. Elizabeth Bradley.
Hello, I'm Liz Bradley. I'm a shareholder with FortneyScott. We are a DC-based woman-owned law firm. I have specialized in, do a lot of work with higher ed, both in wage and hour compliance, and also highly specialized in OSHA compliance and looking at personnel actions and compensation issues in the higher ed context.
Terrific. So we have two great subject matter experts. Let me hit a few preliminary matters, and then we'll dive right into it. So on the next slide, please, Valerie. We'll just note that obviously today's materials are to provide general updates, and although they are legally related, and all the presenters today are deeply involved in providing legal advice, today is simply provide general information for all of our attendees. We would encourage you to certainly consult with either your counsel at your university or higher education institution, or with experienced outside counsel to make sure that you understand fully how the specific laws apply to your facts. Well, let's go briefly then to the next slide and talk a little bit about what we want to do today. We've got an hour of your time. We're going to make really good use of it. We have two great subject matter experts. We've got East Coast, West Coast. We've got all the expertise we need, and we want to drill down on the higher ed space because there are so many unique and challenging issues that we are seeing. And so what this really represents, and we realize from sort of our collective efforts in our practices, this represents kind of the punch list of issues in the last 60 days that our panelists have been seeing and grappling with on behalf of clients. So the instructional adjustments, shared governance issues, compensation. What does compensation look like during COVID, post-COVID, how to adjust it? Obviously, all the workload assignment issues that are very much still being actively decided in most of our clients, and how that's going to impact faculty. And then the concept is very timely also, people are returning to work. The higher ed space is returning to work. There's a lot of discussion about when students may come, whether that's in the fall or not. But in the meantime, faculty, our clients are returning to work. And what does that look like? And there are a host of health and safety considerations and issues involving accommodations and a number of those twists and turns. So what we want to do, we recognize that our experience has been most people feel kind of overwhelmed with just the flow of events. They feel overwhelmed personally. All of us obviously are working from our respective sheltering in place home offices, and that's true, and we all have different family and so forth, and it's all compressed, and we're trying to work and do this. And what we realize is that the ability to try to deal with your issues minute by minute, sometimes you can lose some of these other issues. So our pledge is take 1 hour, spend it with us, and we're going to leave you with a list of issues that hopefully will help you focus and get some further answers. Reminder again, as Valerie mentioned at the outset, we will take your questions, put them in that little chat box. It's one of my responsibilities is to see if we can stay on track for that. All right, so let's jump right into it. Next slide, please. And
Sure.
Natasha, I'm going to ask you to start us off. Thank you.
Great. Thanks for kicking us off. So we are going to start by talking about sort of the concept of instructional adjustments, and specifically not so much the logistics or the academic reasons for doing so, but the employment law issues associated with instructional adjustments. And so, Liz and I have been corresponding over the past few months as this all happened and looking at the employment law issues associated with these instructional adjustments. And we just thought it would be good to make sure that everyone is considering the same issues, particularly as you move towards the fall term and beyond. So we flagged a couple things to be thinking about with respect to instructional adjustments. The first and foremost being, of course, shared governance in the context of your institution. And making sure that as you think about any curriculum changes, program changes, modes of delivery, that you are thinking about your shared governance obligations as well. So we saw some significant complaints arising out of the manner in which things were shifted during the spring, March, April shelter-in-place orders, measured against the obvious urgency of the crisis. And I think what we really want to emphasize is, to the extent you are now spending May and June and July planning for what the mode of instruction looks like, what type of curriculum you're going to be offering based on your ability to return to campus or offer a hybrid model, that you really remember your shared governance obligations. So, you want to make sure you're meaningfully engaging faculty in accordance with the terms of usually it's in your faculty handbook, sometimes it's embodied in your collective bargaining agreement, may also be a reference to it in your institutional bylaws. But we do really think that as you look towards future terms, you would be wise to make sure that you are conferring with the faculty on a meaningful basis. Now, it may be, as we've seen at several institutions, that shared governance process embodied in the faculty handbook needs to be accelerated, right? So it may be that you don't have a year to plan for transitioning to virtual instruction for the fall. But what we want to really encourage is that you approach the faculty and figure out together the pathway forward for engaging in curriculum change and engaging in a change in the mode of delivery in a way that is potentially accelerated under your existing processes. So thinking about how you would do that, we've seen a lot more activity in the AAUP space, which has a tendency to organize the full-time faculty, and they're really focused on the implementation of shared governance. And they issued a position on virtual instruction, which referenced back to their 1995 statement on distance and online education. So, but the principles are the same in that the faculty should be consulted and should meaningfully confer on these types of changes. So, just really encourage you to look at that, check out where your legal obligations arise. And then the other thing that's often overlooked is that your accreditor often has explicit requirements for engaging in meaningful shared governance. So it's not only a legal issue, it can also be an issue flagged by your accreditor. And so think through how you're going to overcome the obstacles of timing or reaching out to those as you seek to implement shared governance. So if we could switch to the next slide, I'll cover some of that sounds all good in practice, and I'm sure you've all considered shared governance, and that's not hopefully news to anyone on this call, but there are some significant challenges associated with fulfilling your legal and accrediting obligations. The first one that we've run into is our 9- and 10-month faculty who are rolling off contract at the end of May and figuring out how you will meaningfully engage them. You want to look at, and Liz is going to cover all your FLSA obligations, but you want to look at when does their appointment start, when does it end, what period of time are they paid for, and then if you're at one of those institutions that stretches out your 9 or 10 month appointment into pay over 12 months, You need to look at what's contemplated by that arrangement, and are they truly being paid to work over the summer, or is that just a payroll attribution? So if you're going to ask people to engage in shared governance, you also have to think about are they performing work on behalf of the institution, such that you need to also think about a compensation structure. Same thing goes for any faculty who are unionized. It's probably set forth in your collective bargaining agreement with respect to what the obligations are while they're under appointment versus not, and you may need to negotiate that as well. So that's sort of the one challenge that we've recently been seeing, is we're trying to sort of hurry up and get things into place by the end of May.
Well, I was going to ask you, Natasha, on that. If you don't have things tidied up, that sounds like great advice. By the end of May, that ends on Sunday. So there may be some that don't quite have things tidied up by Sunday. So what do you do? How do you engage in shared governance if you have faculty that are rolling off of contract? Because I know a lot of them are on or about June 1 now. What do you do if you aren't? I think the right advice is ideally have that tidied up in advance. That may not happen. Then what do you do?
Right. Yeah. Feels optimistic at this point, considering it's Thursday. But there are a few schools that I'm still holding out for. I was like, all right, we can get this done by Sunday night. I believe it. You probably also need to look at, do you have faculty who are appointed year-round? What role do they play in your faculty senate or your faculty leadership? Like, are there already people who contemplated working on behalf of the institution for the summer, such that they could be engaged for the purpose of shared governance? Or we've had a few schools that have adjusted the terms of the appointment to say, you used to start August 15th, you used to start August 20th. We're now going to need you to come back June 15th. And that's a tough message. It upends people's sort of plans and schedules and their life for the summer. But I think if you can identify what the requirement is, why that acceleration is needed, what the expectations will be, and if it's for meaningful shared governance, that's an excellent explanation for why the terms of that appointment might shift.
Sure. Those are good tips. Good. Thank you.
Sure. So another shared governance challenge is the shifting budgets and the shifting enrollment. Many schools moved their admission dates to June 1, so we're still looking for that clear picture of what enrollment might look like. And then because of the antitrust settlement, this is the first year in which some of the enrollment practices will change even after June 1. So we're in this shifting climate with respect to the budgets and enrollments. And to the extent you're going to engage in shared governance, you're going to have to be prepared to explain the financial basis for some of the decisions that are being proffered to the faculty. So just more transparency, I think, than some institutions are used to seeing, but it is not helpful to engage in shared governance without the context of the financial status of the institution, because you'll get proposals that just financially don't work. And then, as I mentioned, there's the procedures for change that are usually in your faculty handbook. Those are usually rolled out over a year or two. And then we see the need for speed here with respect to figuring out what's going to happen by the fall term. So just thinking about if there are ways that can be mutually agreed upon to be accelerated. So it's challenging but doable. We just encourage you not to ignore it or overlook it or hope that it will go away.
Right. Okay, that's very helpful.
Sure. So if we want to move to the next slide, talk a bit more about some of the things that we're thinking about with respect to we put this under the heading of shared governance, the tenure process. This is sort of another employment law issue that Liz and I noticed we hadn't been seeing flagged very often. A lot of webinars about logistics or general employment law, but you also need to understand what the promotion and tenure process will look like for this upcoming academic year. So you may have that in your faculty handbook. I also caution you to reference your institutional bylaws. There's often little nuggets from over the years as to how that process can be modified, what the level of board input and approval is there. So looking at what you've got, looking at the mechanism for changing it, and then figuring out how are you going to administer that process? Will evaluations be considered? A lot of institutions took the position that for spring 2020, it wasn't necessary to complete the evaluation process just due to the extreme duress that everyone ended up teaching under. So thinking about how that process would still need to go forward in 2021, and then any deviations that might need to be agreed upon with the faculty, and then also the option to pause the tenure clock as a means of allowing someone to say, you know what, if you're going to make me teach from home with my dog and kids and everything happening in the background, like I really don't think that this is the year that I should have in my 6 years of consideration. So you do have that option. You also have people who want to proceed towards the application for promotion. So you've got to take into account sort of the different needs of your faculty members. But just another issue to be thinking about so that you're not scrambling in September as you start to implement that process.
Do you see any particular risks in? Do you see any particular risks in pausing that tenure clock from the university's perspective?
I'm a little nervous about a unilateral pause, like to the extent that someone is thinking their career based on the timelines embodied in the faculty handbook, and they're in a position to proceed with that. I think a unilateral pause might be argued as delaying a promise made to them about how they can get to a particular rank, which would impact their salary. Yeah. So
another thing.
Go ahead.
Yeah.
Sorry. Go ahead, Natasha.
I was just going to say that's the voluntary, I think, is for the people who say, you know what, not this year. I can't count this year.
Voluntary. Okay. Mutually voluntary. Liz.
Another thing to think about, and just putting the OSCP considerations in, they're looking really closely at these tenure decisions. They want to know how long it takes to get to tenure. Why do certain people on race and gender take longer? And so that's something to be thinking about, is making sure you're documenting any voluntary pauses in that clock, and that you're applying the permission to pause consistently across, so that you can defend and explain why it took person A, a longer time than person B. So just to think about making sure you're maintaining documentation on that element.
I agree with that.
Yeah.
Agreed. Super. Okay.
So, one more thing
to
to
the
think
next
about,
slide.
shared governance. If you want to go to the next slide, we'll look at some other instructional adjustments. So we put together also sort of what we think are the employment law, who, what, when, where, why, how of instructional adjustments. So, and specifically the legal issues. There's lots of logistical issues. There's lots of academic issues to consider. But first, you have to think about who is going to be delivering your instructions as we enter into a relatively unpredictable academic year. So I'm looking at, for my institution, who's got a contractually guaranteed load, what's the source of that guaranteed load, is that a collective bargaining agreement, is that set forth in the faculty handbook, so what do I need to do to get them to their load, what happens if I can't get them to their load, looking at, and Liz, I know you're gonna talk about some of the compensation that might be associated with that, but also this concept of you may actually need more people. And so, we've been thinking about enrollment challenges, and you might not be anywhere near the enrollment numbers that you're used to, but with the social distancing, depending on the model of instruction that you're going to use, you might actually need more faculty members. And so thinking about how that's going to play out, some institutions are looking at whether their full-time faculty are going to have an increased load based on that. Some are looking at using contingent faculty members to handle that. So thinking about all your contract obligations, think about what you need to offer legally, right? So this is like we hope for the best and draft for the worst, right? So you need to get people through their programs. What is required to get a cohort through? What are the minimum course offerings that are necessary from an accreditation perspective, from like the state requirements for certification for teaching and nursing, like what do you absolutely have to be offering, and figuring out legally the plan to get there. That will impact the load and assignments. That's the who, the what, the where has started popping up recently as people have started to migrate to other homes out of state. You really want to look at where people are performing the work. So we're seeing people now engaging in virtual instruction from states other than they usually reside in when teaching for youth. So it's worth it, we think, to do an audit and an update of where will people be, where is their primary place of business particularly for the fall term as people have moved around. So that's a whole thing.
Liz, before I call on you, let me pose a question from our audience. The questioner says yes to shared governance, but in the end, do you see the ultimate decision as to whether a course is taught online or in person as one for the university to make, and that a faculty member may not refuse to teach one way or the other on the grounds that it violates academic freedom? So ultimately, who makes the decision, whether it's taught virtually or in person? And what is the impact on academic freedom? Natasha first, and then Liz, I'll come to you because you've got a comment.
So it's kind of a two-part analysis, right? Who makes the decision, and then once that decision is made, what can you compel an individual faculty member to do? I would say in general, the administration and the board likely have the corporate authority to make that decision at the end of the day, but check your institution's bylaws, check your faculty handbook, check your faculty senate constitution. There's probably something explicit in there about the mode of instruction. As I said, the AAUP has been on this issue since 1995. So, it may be that the faculty have conferral rights. It may be that they have input, or it may be that they have the decision as delegated to them by the university long ago. So definitely check institution specific. And then once you've satisfied that, like if you've engaged in shared governance over the summer, and that's the university's decision or the university and the faculty senate decision, then we will talk about whether you can compel someone to come to work consistent with disability accommodation analysis, consistent with sort of the other principles there.
Including academic freedom. Including academic freedom?
I don't think it's going to be a position of academic freedom at that point. I think there's a
I agree. I think that's kind of a red herring that a faculty member might throw up, but I think we would push that aside. Okay, Liz.
Well, actually, I wanted to tee back to the where question for a minute.
Okay.
So, and one of the things to be thinking about there is, are you going to redefine principal place of business? Or are your workforce still going to be assigned to the location of your university, or are you going to allow them to be moving to different locations? And think about you look at local tax laws. How are they being tracked right now? Where are you obligated to pay unemployment taxes versus where they're moving? So take a pause before you redefine multiple principal places of business, and likely still have everybody assigned to be working from your university, but allowing them to be working remotely. So be careful and think about some of the terminology that you use, and make sure you're not triggering some tax law implications.
Let me ask one other audience question, and I think this is a good one. Annie, and I'll throw this, both of you can answer, and I'll start with you, Natasha. Any thoughts on a centralized review for requests in order to address equity concerns? In other words, so we don't have one school or college doing it one way, one the other way, et cetera. Do you like that centralized approach, or do we adhere to the traditional everyone special snowflake, separate schools and decision making? How do you balance that in these decisions?
So I'm going to put my employment lawyer hat on and say centralized is always better. A lot of my institutions are completely decentralized, but from a disparate impact analysis, from analyzing the tenure clocks and the disability accommodations we're going to talk about, centralized is always better.
Okay, Liz?
I hope you agree.
I agree. Holy.
I think that's the right answer, although from a programming standpoint, it's always more fun if you disagree. But I think you should not disagree on that.
Yeah. But I will say, there is still that point of the dean of each school is a key decision maker. So there may be centralized policies with a little bit of discretion within each school with regard to, for example, I know tenure clocks sometimes differ based on the type of program, just from the fundamental baseline of it. So there may be some necessary differences.
Okay. Well, let's pivot.
And I would just want to see those.
I'm going to give you the final word. Go ahead.
I was going to say, I just want to see those necessary differences approved at a centralized level.
Exactly. There you go.
I would agree with that. Okay.
So we'll move on.
So now that we've gotten all that squared away and straightened out, I'm sure that's crystal clear, but no, that's a very, very helpful discussion. Let's move to another block and discuss some other equally critical issues, and this deals with compensation adjustments. So next slide, Valerie, please. And in this, there's a whole host of issues, obviously involving both federal law as well as state wage and hour law. We're not going to detail all the state wage and hour laws. We're going to focus primarily on federal, but we put a big marker there. Have to look at the state laws in these areas always, but particularly compensation adjustments. So Liz, I'm going to ask you if you would start leading this block, please.
Sure, great. So a lot of what we're seeing, and not just in higher ed, but across many industries, is doing compensation adjustments in order to address budget concerns. One of the things that we do recommend is a holistic approach. Again, this goes back to the centralized discussion that we just had. So one thing that we're seeing is a universal 10% across the board of salaries, or some sort of whole approach and uniform approach across all is what we're seeing a lot of, and that will eliminate questions about whether it is done, adverse impact against minorities or women if you do it centralized and uniform. That's a recommended approach. But one thing to think about is watch your CARES Act 2 obligations. So to the extent that anybody, and we could do 3 of these
Let me interrupt you.
Act.
Just to be sure, let me interrupt you for one moment. What is CARES Act? Just define that term, because that may be one people aren't fully familiar with.
So under the CARES Act, there's the loan guarantee program is the piece that we're talking about. And so that going into that is under the loan program, you get the loan guarantee, but you have an obligation to have an intent to return 90% of your workplace, but that's what we're talking about with compensation. But the key thing you need to remember on the compensation side is that you are committed to restore your employees back to their standard compensation level within 4 months of whenever the end of this emergency is. So if you are looking into the loan guarantee program and you have applied for that and you've taken the loans for that, remember, if you're taking compensation adjustments now, you need to be remembering to adjust those back up. So that's something to be thinking about as we go through the rest of these discussions about what compensation programs you may be looking at adjusting. So again, and we've talked about this a few times, but first place to start if you're going to make compensation adjustments are your appointment letters and your collective bargaining agreements. That's your baseline. We're going to talk about the FLSA and state laws, but a lot of your workforce, your faculty, are either governed by appointment letters, collective bargaining agreement, or both. So you need to start there. And again, a little caveat here, I think for every piece that we talk about when a CBA is involved, if you're going to make adjustments, if you're going to be making changes to that workforce, either their schedules, their compensation, anything about them, you need to start having those dialogues with the union up front and early. Most unions are much more agreeable and cooperative if they are part of that initial discussion, rather than you coming to them with a final, what appears to be a final decision, and then you don't want to walk into a failure to negotiate a mandatory subject to bargaining type claim. So pause point on that. Another area to start thinking about.
Hold on, just pause for one moment, Liz. I'm sorry, Natasha, comment?
Yeah, I was going to say, and it's been our experience, we were discussing that the unions have been pretty amenable to these discussions so far. So that first week at the shelter in place, I was like lighting up the unions about like, hey, we're going to move to virtual instruction. Hey, change here. And so I think to the extent, and that was, as I said, more of an emergency situation back in March. And so now that you're sort of contemplating what you're going to do next, I think you need to be also working backwards from implementation date to approach the union on that. But Liz, I know you, sort of the East Coast, West Coast perspective so far, we found that the unions have been amenable to discussing this.
Yeah, I agree with that. And I think, the union's goal is to keep their employees employed. And so if it's a matter of having to reduce the workforce or potentially reduce salaries for a short period of time, that is a better solution for all also. So they have been, for the most part, reasonable to be working with and coordinating with solutions in just very strange times. Another piece just to look at, and this should not be a barrier in reducing salaries, but just keep in mind, some of your faculty may be getting a portion of their salary from grants. So you may have an obligation depending on how you reduce the salaries and what bucket of money you take the reduction from or how you do that, you may have an obligation to update your grant certifications about how much compensation is coming out of the grant funds. So just keep in mind to be looking at those comp levels for your grant-funded positions. And finally, again, we won't go into much detail here, but be cognizant of immigration issues. So to the extent that you have employees that you filled out immigration certifications in order to get their visas. So some of those certify about an inability to get that type of worker in the workplace. But remember, we have record unemployment right now. So are you still able to certify that that type of worker is no longer available? And again, I know that goes a little bit out of compensation, but those certifications often include a compensation component. So I would take a pause there and, look at when you're doing your compensation adjustments, take a second look at anybody on that roster who's going to get a reduction that is a current visa holder and look at what your obligations are with them with regard to their specific type of visa. So then moving on to the next slide, they're in the sort of return to work world. There is a lot of pre and post work COVID related activities that employers are starting to put into place. For example, temperature checks, questionnaires that they're filling out, other types of information gathering to understand whether the employee is healthy or at risk to return to the workforce. And I know, David, you have been working with a number of clients, both in the higher ed space and in corporate, about the various tools that they're putting in place, some that are outside of the work hours, some that are in work hours. Can you give us a little summary of what some of those tasks are so that we put this into context?
Sure. And I would just start by saying that the metrics that people are following are changing rapidly. I mean, the CDC guidance has changed over the last couple of weeks. States and localities increasingly are developing and implementing their own guidance requirements. So with that kind of caveat on the front end, this is pretty generalized, what I'm going to say necessarily, and you need to make sure that the particular your location that you are dialed in on what the requirements are. That being said, temperature check is a very common component in a lot of the guidelines. Most of these are guidelines. The operative temperature is 100.4. There's a variety of ways that those that opt to have a temperature check are going about it. Some are having employees do it at home and self-certify. Some are doing it as people come into the workplace. When you see those little handheld, no, we're not using the old thermometers that you put in people's mouths and so forth. These are the handheld. But then you get into the whole issue of who's collecting the information, what do you do with the information, how do you deal with that? Some people are using third-party administrators to collect the information. We'll talk a little bit about whether that information and the privacy concerns that attach to that information. One thing that I think I've seen in the last couple of weeks as employers have begun to grapple with high volume collection of temperature information is they really don't need to know whether Johnny or Susie have a temperature of 98.6, 99, or 100 even. What they need to know is either you're above 100.4 or below 100.4. That's kind of a gateway. So you're red, green. Yeah, you're above or below. And so they're maintaining that type of record. Another thing, an issue that has come up is that people are realizing that some of these temperature records may constitute a medical record under your OSHA obligations. And in contrast to most employment records that are kept for 2 to 6 years, an OSHA-related record of this type is kept for 30. No, I did not misspeak. That's 30 years, which is kind of mind-blowing. So most people involved in these decisions are not necessarily OSHA practitioners. So the concept of temperature check, collecting this personal information how you collect it, what you do with it, and similarly, background information. We spend most of our lives saying we don't want to know what people do outside of work because of privacy concerns. We're really focused on what they do while they're at work. Well, actually now, to some degree, we have a legitimate interest in trying to understand what you are doing outside of work. Last week, did you travel to Brazil? Last night, did you have a family member in your household who came down with the COVID illness or COVID symptoms, et cetera? And so appropriate ways to inquire and collect that information. The short circuit answer seems to be, I think, a better practice if you're going to go that route is using an app, and there are a number of apps that are being developed to help collect this efficiently. Some people are putting it onto a splash screen so that when people start their workday, they get to work, they have to go through those questions and they're either screened in or screened out. Some, I don't recommend this, but we do have some clients that have opted for people do all of this at home. It's kind of what I call the honor system. And you self-certify by presenting yourself for work. I have checked my temperature. Everyone at home is healthy. I'm not a risk factor. I'm feeling just fine. And I don't have any of the other symptoms. So these are things that, depending on what's done and how it's done, may or may not trigger into the compensation issues.
Right. And thank you, David. And I think we can all agree the splash page that comes up once you're sitting at your desk in the splash page and you fill it out, you're already at work. That's compensable time, but that's part of your normal work hour. So that's not getting into the creep that we're going to talk about. But the questionnaire at home, is that compensable time? Okay, the amazing legal answer is it depends, right? And I think there's an argument under federal FLSA law, there's an argument that it's potentially not compensable time. And there are some good cases out there that go some of the bag check cases. There are various things, and a lot of it looks at how burdensome, how much time it is, and what they're doing and as such. But be careful, because I'm going to tell you, in California, it's going to be consistent. Natasha can chime in on that. But you have to look very closely at your state law about whether or not these type of outside of your scheduled work hour time is going to be considered compensable. And again, if it's a union, if you have a CDA in place, the union is definitely going to take the position that that's compensable time. They're going to try to collect wages for their employees for that time. So then to think about that is you need to make the decision, is there a risk that this would be compensatory time? If there is, and you choose to pay for this time, there's two ways you can go about paying your employees for this. And I want to point, this is your non-exempt workforce. These are your employees who are paid hourly. But I know a lot of you there's part-time faculty that are deemed non-exempt. So this would be those workers. It would be any other employees that are not paid on a salary basis. So one option is the obvious, pay the actual amount of time spent. Well, that sounds easier than it actually is, because to do that, then you have to implement methods to track that time. So in addition to filling in the questionnaire on their free time, they have to fill out a timesheet on their free time. And then how do you submit that time, track that time, verify that time, and ensure that it's done accurately? Another option that we are seeing companies consider and implement is doing an estimate of the time. And so they're performing estimates of how much time on average these tasks should take, and then automatically allocating that amount of time into each pay period and paying people a blanket amount of money for those. I would make sure you maintain the records of those tests, everything to document how you came up with that estimate. And again, run that by any union that you are working with. So those are some of the pre and post considerations for your hourly employees. The next slide.
In California, your California faculty who do not meet the exempt salary threshold are going to be considered part-time, and you need to really factor in the actual time spent. And then you also need to factor in, to the extent they're doing it before work or before they arrive on campus, meal and break period calculation. So California is going to be super tricky. I would not estimate anything.
Yeah.
Meal and break, and I'll say one other thing on that continuous workday, because if you start your workday at home, then have you converted the time that you now, if you instruct people to do this at home, have you converted the commuting time that normally would not be compensable into compensable time as part of the continuous workday? So I really think this wage hour thicket needs to be very carefully mapped out. It isn't just, oh, let's feel good, let's start collecting this data and do that appropriately, which is its own challenges. But then what these consequences are, I think, are very significant. Liz, before we move on, I want to roll back, and this is an audience clarifying question. Quote, when you say CARES Act Part 2, are you specifically referring to the payroll protection program?
Yes.
It's part of the, yeah, no. It is. The answer is, I believe it is part of the post-COVID crisis federal relief program. And this is not necessarily, not the PPP program, but the other loan program is what the provisions are that you're talking about in CARES Act 2. Okay. Where are we? Anything else on this slide? Yeah.
No, I think we're ready to move on to our salaried, our exempt employees.
Sure.
And so just briefly here, now most faculty members, if you're just falling under the FLSA, and remember, state bakes on top of this, but speaking about on federal FLSA compliance pieces, most of your faculty likely fall under the professional exemption. Remember, if you're going to be doing across the board reduction in salaries, you still have to meet the applicable salary basis test. Federal provides you the baseline. That's going to be the lowest. So if any of your faculty members or other employees, if you reduce their salaries and you drop them below the 684 or the 35,568 level, they will lose their exempt classification to convert them to hourly employees, and all of the fun that we just talked about a minute ago about tracking time and how to confirm and the continuous workday, all of that starts to play in for those employees. So take a pause there, and remember, states and localities have higher thresholds, so you need to look at that. So some things you can think about when doing these, if you can have a standard approach where everybody's getting a 10% salary reduction, and you should phrase it as either 10% or to the salary basis test. So that way it's standard, and you need to make a decision up front whether you're going to freeze those people at the salary basis test or if you're going to convert them to hourly. You have that option. But remember, if you do not plan to bring your employees back up to their pre-COVID salary, by doing that freezing, you have created a salary compression at the bottom. So keep that in mind. That's going to be an issue that you should work to correct going forward so that that compression doesn't continue and ultimately possibly could result in some pay equity issues going forward. That's just something to be mindful when you are reducing your salaries.
Okay.
I think moving on.
Next slide.
Yes. So one thing that I think we are going to likely see in the higher ed world, because it's a pretty common concept, is reducing your salary based on reduced workload. We see that a lot. So often salaries in higher ed are based on one FTE. But somebody's like, I'm going to take some time to do research, or I'm going to do, and they go down to, it's pretty common to be at, a reduced percentage FTE. This may be something that we're going to be considering. So as Natasha was talking about, reduced class schedules and modifications to their schedules could result in compensation changes. Just be careful to do the legwork first. So under the FLSA, if you tell an employee, you don't need to come in, you only have to work half a week this week, we don't need you, we don't have the demand for you, you still have to pay them their full salary under the FLSA. So in order, you can't just unilaterally and without notice say, I'm paying you half your salary. That's not permissible. But what you can do is reduce their salary. Just do it proactively. We recommend you give them notice of that. Let them know that the date that is go in. So then the new reduced salary is their full salary for the week going forward. So you don't run into any FLSA issues with that. check your states. I know, for example, in DC, you are obligated to give written notice of compensation changes. So I know other states, California, I'm sure California has very similar obligations and detailed obligations that include the timing of when those notices need to be made. So it can be done. You absolutely can reduce the salary. You just need to make sure you comply with some of the legal logistics to get it done first. Another thing to be thinking about is, I know I'm beating the CBA horse here, but look at your CBA provisions and see what kind of obligations there are to make salary adjustments. And finally, the 9 versus 12-month salary considerations. So that is a way that potentially the university could delay the burden of paying by converting people to 12 months to spread it out, or you can allow employees to have that option. Again, be careful. There are legal requirements about ensuring that compensation is paid within a certain time of the work being performed. So if they're not doing work for all 12 months, converting them to a 12-month pay cycle could violate a number, many states have provisions on that piece.
Natasha, any comments on those?
Yeah, that was a pretty common issue out here in California, where people are 9-month faculty and the pay was spread out over 12 months. And really the only fix is to have the payroll lead so that they're paid in advance. So you can always say that you're compliant with the statutory deadline for receiving wages within the time after the work has been performed. So, but most people didn't want to do leading payments. So a lot of people switched to, okay, if you're a 9-month faculty, you're paid on 9 months. And so you just have to, again, be careful, as Liz was saying, when you look at someone who's on a 9-month salary, they're in the humanities, they're an assistant professor, you start doing 20% pay cuts, you're probably running pretty close to California's minimum salary, if not others. And then just the other tip that I've had is that often these salaries are set by your appointment letters, and so we've been inserting into our appointment letters the ones that hadn't gone out by March 1st. Those were rough. But the ones that hadn't gone out, we've been inserting the right to reduce the stated salary if the salary is promised in that appointment letter. So just if you haven't already issued those, be careful, because that can be a source of promise as well. I think we'll cruise to the next slide.
Clause, right? A force majeure type clause. That's good. Good.
And then one last thing, and we'll touch on this very briefly, but in the next slide, another place other budgetary considerations to reduce compensation overhead is potentially implementing a voluntary retirement program. That's not going to get in by Monday. They take a while to implement and to roll out. You need to think through those, but that is a program some universities are considering in order to assist with this. Also, another consideration is reduction in your course releases. So faculty who no longer have to teach as many classes in exchange for some of their admin or other mentoring type duties, they now have to go back and be teaching those. So you don't get that sort of free money, although they are working for it. And then reductions in retirement contributions and/or changes to the fringe benefits and types of travel professional development. So those are some other areas where you can reduce the monies paid to your faculty in order to try to save your budget in some ways.
Go ahead, Liz.
Oh, I was gonna ask if there were any comments on that.
No, I think what we're just seeing is it's all on the table.
Exactly.
Everything's on the table, yeah, because the financial situation is becoming acute. All right. Well, let me suggest this. We have 2 blocks. We have 10 minutes. I'm going to suggest we have a block dealing with some health and safety issues and so forth. I would suggest maybe we pass on that. We've got the slides and materials for folks, and then we go to the questions that I think people are really imminently facing, dealing with returning to the workforce, the reasonable accommodation questions. I've gotten some of those questions already on the screen. So as Valerie's going through some of these slides, we're going to leave these as takeaways, but as we're going and Valerie, advance to returning to the workforce, please. But I'll just note, as we're doing that, That's perfect. In the slides that you'll get from the program, there's a good bit of information, including the sites back to either federal OSHA, and that can lead you to the appropriate state plans or 28 state plan states, and the operative provisions of both the CDC and OSHA, and the concept of a general duty clause. What we're finding is most folks that deal with workforce compliance issues, like EEO and these issues, have little to no knowledge of OSHA-related matters, beyond sort of recognizing them, because in most practical terms, you never think of OSHA as applying to an office environment, a schoolroom environment. Well, it does, and it's the same set of laws that apply whether it's a meatpacking plant or anything else. So what we've done in those materials, we've given you a number of nice summary materials that highlight for you, along with all of the links that go back. And depending on what level of interest and response we get, if there's a hunger for that and sufficient interest, we can stand up a quick program to really help you dive into that a little bit. But that is the fact that we're skipping it is only a reflection of time. It does not reflect the critical importance of that. So with that said, let's focus now on how we're getting people back to work. When we know one of the most common problems in the survey bear this out is people are saying, it's great you want me back, I don't want to come back, or I'm scared to come back. How does the employer, how does the university or the college respond to that? Natasha, I'll ask you to start that.
Yeah, so this is going to be, I think, where we're going to spend a lot of time, this and the wage and hour issues in terms of what the rules are. So, of course, the EEOC has weighed in recently, reminding employers of their obligations to provide a reasonable accommodation process. You, hopefully, at your institution have your Section 504 coordinator, or accommodations are administered through HR or some other centralized function, but really figuring out, usually tapping into your existing processes for when someone is requesting a reasonable accommodation, what type of medical certification is required. We've been doing a lot of waiving of the need to show a COVID diagnosis. I mean, as an employer, you're really not supposed to get the diagnosis anyway. But it was so hard for people to get medical attention for a while that the consideration was that you wouldn't need to show a COVID diagnosis. But as we move forward and as the healthcare system kind of recovers, hopefully, knock on wood, thinking about what the accommodation process is going to be. And then you have a huge decision point. And Liz and I have spent a lot of time talking about this. There's no right answer here. There's like legally required accommodations for people who can show the appropriate medical certification and for whom you could engage in the interactive process and provide a reasonable accommodation. Working from home is probably going to be the reasonable accommodation. And since you've just administered that, it's going to be hard to show that it's now an undue hardship unless you are looking at the particular position. But then there's all the other people who cannot meet that standard, and figuring out what your institution as an employer is going to do for people who are fearful of returning to work, people who live with someone who is vulnerable or is also fearful. Those are not things that are going to be addressed necessarily through your disability accommodation process, because they're not going to meet the standards established by that process. So you can have an internal policy decision on how you're going to handle those. I would recommend most faculty do not have job descriptions, right? Job descriptions are critical for conducting a disability accommodation analysis. So, you know, you really need to think about, hopefully you've got something somewhere that you can dust off and say, these are the essential functions for this position. But so you're going to have to really think about what's your internal stated policy going to be and how are you going to handle that. And this one, I've been jumping up and down saying it's got to be centralized. Because some people are sympathetic, some people are not sympathetic. You know, some people are like, no, you need to get back here to the classroom. Like, this is going to be really hard. But legally, I am not aware of anything that says if you are fearful of returning, you don't have to return. Or if you live with someone who's more vulnerable, maybe they're higher in age, that you therefore have to return. But as a morale, as an employment culture, that may be the position you take. It depends on what your institution can offer. Depends on the mode of instruction. You know, Inside Higher Ed's got 15 different possible modes that you can offer next fall for online, in-person, mixed, flex, hybrid. So it depends on what you're doing and whether you can accommodate it. Liz, I'm on my soapbox, so I'll get off for a minute and give you some.
Liz, I want you to jump in here. Go ahead.
And I think, while I completely agree with the approach previously, we were not asking diagnosis information, we were letting that go. I think those days are coming a little bit to an end. I think because there's going to be a creep and there's going to be a slip and the fear element. We need to be consistent in what our policy is and implement it consistently about whether fear is going to be enough for our facilities, for our institutions, right? And if you are going to start requiring it to be based on a diagnosis and going back to the ADA and somebody having the illness or of the other COVID-related reasons to be out on leave, I think we need to start being consistent with requesting that documentation. Just the way you ask for medical documentation under the ADA, there's ways that you file that separately. You don't put it in the personnel file, you protect it. There's those rules, because I fear that if we're soft with it at the beginning, because we want to support each other and we want it to be a collaborative opening, I think that's going to creep, and 3 months from now, nobody's going to want to come back to work. And then how do you handle it on a pro-hoc way? So I think there needs to be consistency on how the approach is going to take and across the Institute.
Let me ask an audience question. Liz, I'm going to throw this to you. If we give, and I think this has been slightly covered, but I want to make sure we're crisp. If we give the staff the option of returning to work unless they have a pre-existing condition that makes them high risk, so that's asthma, age 65 or higher, and a number of other situations, do we have a legal right to ask them to provide a note from a physician? So this isn't necessarily, as Natasha explained, it's not a disability vis-a-vis the law, it's a pre-existing condition that makes them high risk vis-a-vis COVID as defined by the CDC. Question, do we have the right to ask for a doctor's note? I suppose if it's because of their age, we know what their age is from their employment records. Asthma, let's assume. We never heard ever that they had asthma. Now, Sally raises her hand, I'd love to come back. I'm really worried I've got asthma. Do we have a right to get a doctor's note? Liz? Yes.
Yeah. Well,
okay.
first of all, I want to say
round.
make sure it's voluntary, but yes.
Okay. Natasha.
Yeah, I would say yes. Essentially, they are invoking, in a roundabout way, a disability accommodation request of wanting to work from home. And so you can require that they've got a disability, they present documentation that shows they have a disability that affects a major life activity, in which case they'll bring you the note that says, I have asthma, or my doctor says I'm in a high-risk population. So I think
but they may just have asthma to the point that it's not even though it's not necessarily a protected disability vis-a-vis the ADA or 503, the laws, we would effectively, under our benevolent policy, we're going to treat it and run it through our disability protocol.
And just
Liz,
to that, David,
or does that make you nervous?
No, a best practice recommendation, I would say, is modify your ADA policy to state that you will allow reasonable accommodations for the expanded disability reasons for a pre-existing condition for COVID-related reasons. Do a little caveat in it and say all the documentation requirements apply. You could bake it in that way and define it tightly.
Okay, I'm going to give you each about 30 seconds for the. Go ahead.
You mentioned age. Just be careful making unilateral decisions based on age. I know the CDC says it's vulnerable. A lot of faculty are in the vulnerable age population. That's not a valid basis for making an employment-related decision. You can take it into it.
That's correct. We're talking about what you do voluntarily. You cannot say affirmatively just because you're in the protected, you're at the high risk category that you were precluded from coming back, or we don't want you to come back. The EEOC has made that clear. That is a violation. That's a violation. Well intended, but a per se violation of the law. All right. I'm going to ask you each in, say, no more than 30 seconds to give your final thoughts, because we have drawn right to the top of the hour. So, Natasha, you started, so I'll start with you, and then Liz, I'll give you the final word. So, Natasha, 30 seconds.
So, my final thought on this topic and why I enjoyed Liz and David suggesting this was that faculty tend to operate in a space that does not often get touched by human resources or employment law. And I think we're going to see significant employment law overlay as faculty return to work. I think we can do a whole separate webinar on staff returning to work, but there's a lot of discussion about faculty that I think needs to really get tightened up.
I ditto that. And I think we're already seeing a heightened focus on faculty. Like I said, OFTP's focus on faculty compensation it's at the forefront of one of their missions. So we're not just seeing this, it's not just conceptually, we're seeing government action on it, and these types of activities could ping into some sort of pay equity and other concerns within our faculty, so we should be looking at it closely.
Terrific. All right. Well, our time has drawn to a close. I want to thank both Natasha and Liz. Thank you both. It's a really excellent discussion. For those in the audience, we're going to probably in around 30 days, the end of June, date to be determined, we'll let you know. Try to put together another one of these, focusing on the higher aspects within the higher ed space, because there are so many nooks and crannies that are unique to this issue, these issues, and this setting. So with that, I would bid everyone a good day. Thank you for joining us. Natasha, Liz, particularly thank you. Valerie, you can close this out, please.
Thank you, everyone.
We would like to thank you for joining us. As a reminder, you may view this briefing on FortneyScott's website at www.FortneyScott.com, and all registrants from today have been registered for future higher ed briefings. Be on the lookout for additional updates, which will be sent via email. Later today, you will receive a survey requesting feedback for today's presentation. You are able to submit suggestions for future topics through the survey. Thank you in advance for completing the survey, and of course, if you have any questions, you may submit them via email to info@FortneyScott.com.
Terrific. Thank you all.